Good morning, everybody. I'm George Swift of the Chamber Southwest and the Economic Development Alliance, and this is our new normal. I don't know how we made it without Zoom, but we have been able to have a number of programs, and like we had our member orientation this morning, we've had our board meetings and executive committee meetings by Zoom, and it's really been a lifesaver. The biggest question we get, and we have received hundreds of phone calls here at the Chamber, when can we reopen? What do we need to do? There's a lot of uproar going on. And when you look around our area, by the way, we have had more businesses open than anywhere probably in the state. They may not be open at a very high level. They may be 25% of capacity. And other than restaurants and the casinos, which are the casinos are completely shut down. Most businesses are functioning in some capacity. Just like us here at the Alliance, we're closed to the public. Most folks are working remotely, and it's worked out really pretty good, other than we haven't been able to call on people in person, which we need to do. So this is a big issue. I want to thank our panelists for putting this program on, because I think it's very helpful. And we'll turn it over now to Amanda White.
Hello, everybody. I'm Amanda White. I'm the Vice President of Communications at the Chamber. When we first started talking about reopening, I knew exactly who we needed to reach out to. So we asked iSHRMA to come in, or IC-SHRM now, and talk to us about the HR and legal ramifications of reopening. Today's panelists include Christina Dedeveau. She's with the Safety Council of Southwest Louisiana, Jeannie Stevens with Cameron Communications, Janelle Johnson with PPG, and Ross Raley with Stockwell Siebert Law Firm. So we are going to hand this off over to Christina Dedeveau with the Safety Council, and she is going to get us started.
Hey everyone, I just want to first start by saying that this presentation to you was collaborated with Stockwell Siebert. And if you don't know much about IC-SHRM or Stockwell Siebert, IC-SHRM is a human resources management organization. We have professionals as part of our organization that are in the HR field or that manage human resources functions. So that includes managers, directors, owners of companies that are trying to keep up with the everyday struggles of human resources. Stockwell Siebert Law Firm was founded in 1934, and they're the largest law firm in Lake Charles, recognized for its high professional standards and ethics in the Martindale-Hubbell Register for Preeminent Lawyers. So we partner together, and we quite frequently partner together to bring programs to you. So to get us started, here we all are. We've probably have over 20 plus years of HR experience to bring to you from the HR side. And I've been working with Ross for a little while, 20 plus years, and I'll let him talk to that. But we're going to bring to you today some things that we've seen that have been common struggles with our HR field in our companies. And then feel free to put in the chat any questions you might have so we can address those throughout the presentation. So the agenda is going to look like we're going to talk about some general guidance and about creating some policies, the communication plan to your employees. So if you're bringing them back to work, or you've been open this whole time and people are coming back from leave or furlough, what does that look like? We're going to talk a little bit about government guidance and being aware of potential discriminations, maybe some policy changes you need to do, and then talk about those employees that are exposed to COVID-19 and how do we handle that. And then at the end, of course, we're going to have some Q&A. So to get us started, the general guidance, looking at infection control, the first thing that we did here, and I know a lot of us take, if you're part of a small business, and the Safety Council is a small business, we need a safety manager. So luckily we have one on staff. But if you don't have a safety manager, what do you do? So you need to identify somebody within your environment that is willing to take charge of all those changes, new recommendations and updates that are put out by the government and the CDC and OSHA in order to keep your workplace safe. And so that person would need to coordinate with leadership what the health guidelines are, what should the infection control plan look like, and follow up with employees in order to implement those things. So our safety manager and HR here, we collaborated together, and we pulled together communication that went out to all employees that helped them understand what our expectations were moving forward. What does it look like when we have a pandemic going on? It's not the normal everyday process. It's things like face masks and other things. So what exactly does that mean for your organization? Creating a policy, and I don't know if anyone else on the panel wanted to speak to that.
Okay. I'll just chime in about the establishing kind of a point person. I think it's a very good idea. It's not necessarily, a quote unquote legal requirement to have somebody who's going to be your go-to for all these new COVID issues, staying on top of the laws, regulations, guidance that are being released. But it's a good idea to have somebody because there is just so much coming out on a day in and day out basis. And, it's not just new guidance or regulations. It's also guidance that covers the regulations that have come out over the past 2 months, where they're explaining further what certain terms mean and how these things are supposed to be interpreted. So I definitely think that that's a great practice for businesses, and whether it's one person or a couple people that you want to have focus and stay on top of these things, it's a great practice to do.
Yeah. Our safety guy, he and I will bounce off of each other. So I'll come by, I'm like, did you hear about this? And he'll come by, did you hear about this? And so we kind of keep each other in the loop. And if you have that person that you're on your staff, great. But the next piece, which is formulating a policy, is the part that holds them accountable. Right. So you can say that you have this great infection control plan, but if no one ever follows up with it, or if somebody refuses to hand sanitize or do the things that you're putting in practice, what do? Well, you got to fall back on this policy, right? That says, here, you agreed to do this. So I don't know what Ross's feeling is about that, but that's kind of in our HR world, we kind of hold people accountable through that paperwork part.
Yeah, the acknowledgement form is a great idea, especially with some of these return to work situations, and making employees cognizant of what we want to do to maintain a safe workplace going forward. Once you have everybody returning, we're still going to have employees who could be contracting the virus, getting COVID-19, having symptoms, and then of course other employees who may be exposed or around that other employee. And we want employees to understand that, hey, if you begin showing symptoms, you need to let management know, and we're going to want you to go home and go through and comply with the various guidelines, such as the CDC guidelines for returning to work, and to ultimately be able to hold employees accountable, to ultimately prove that employees are aware of our policies. What do we have to usually do? We got to show that they were either trained on it or that they signed some sort of acknowledgement. So certainly, while again, an acknowledgement form isn't necessarily a legal requirement to do, I think it's a good practice.
Absolutely. And the next part kind of talks about that flexible shift and work from home. And you may or may not have this implemented with your work facility. There's a few different reasons why you may want to think about doing it if you're not, and that is for infection control purposes. So having two different teams, one working 1 week, one working the next week, just so that they don't cross each other if someone gets sick, is one of the things that we've implemented here. And then of course the reason of being shorthanded, so if you don't have enough people, maybe a good way to entice them to come to work is to do this flexible work scheduling. Janelle, do you have anything that you're doing at PPG?
No, not currently. No, we're still running 24/7. Although we were not fully staffed at the moment. But yeah, we're still running our schedules. But I am aware of other. I do have other plants in other states that I'm responsible for, and we are doing that very thing where we are alternating shifts, so that especially where there are cubicle environments or close working environments, that way we can keep the physical distancing, and we're doing the sanitizing in between shifts and that type of thing.
Yeah, absolutely. So, I mean, if your business is people working right next to each other, think about, is that the safest method? And so you might want to implement this flexible shifts or work from home. And then moving on to the screening check. So recently, the EEOC has approved businesses to screen employees, which include taking temperatures and asking health questions. And so I know, Janelle, that you have some specific questions that you guys ask. So what does that look like?
Yeah, and I think what we're using is, I think I can safely speak for most here as well. We're all using the same basic questions, which are, are you well today? Have you had a temperature in the last 72 hours? Have you been out of the country or on a cruise ship or a riverboat or anything like that recently? And have you been exposed to anyone who's tested positive or had COVID related symptoms? Once they answer those questions, if the answer to all of those is no, then we have a temperature scanner that we take their temperature, and hopefully their temperature is acceptable. And our guidelines, CDC is still using 100.4, which is what is defined as fever. We've actually lowered ours. It's 100. So if you have a temperature of 100 or below, you're screened out and not allowed to come into the facility. Not only for employees, but all visitors into the plant, contractors as well. So,
Ross, do you have anything on the EEOC new guidelines?
Yeah, and this whole thing with the screening checks, it's actually a pretty substantial change from what the policy has been pre-COVID-19 pandemic. It used to be, we'll start with taking a temperature of an employee. Under the ADA guidance, that can be deemed to be a medical examination and something that employers in general would be restricted from doing. A few weeks ago, the EEOC came out though, and they said, look, we believe that the circumstances in this case, because of the health concerns, serious health risks in play, that we believe that the circumstances during the pandemic do justify employers taking temperatures of employees. At the same time, they had kind of a caveat in the guidance. They said, look, understand at the same time that taking a temperature one way or another isn't determinative, right? In this situation with COVID-19, you've got asymptomatic carriers who might not even have a fever, or you could have somebody who has a fever and doesn't necessarily have COVID-19. The more recent development was just in the last week or so, they came out and went even a step further, and now they've basically given clearance to employers to administer COVID-19 tests to employees, to do the actual test themselves. Now, of course, that assumes that the employer has the tests handy, and there's a whole host of other issues that come into play with obtaining the tests, paying for the tests, all that sort of thing. But it's a pretty significant change from what the guidance was prior to the pandemic, and it shows that the government, in releasing this guidance, understands the health issues that are at play, the tough position that employers are caught in. On the one hand, trying to maintain a safe workplace, while on the other hand, respecting employees' rights to privacy, so to speak, in terms of their medical conditions.
So is it HIPAA protected?
Well, one thing about HIPAA you got to remember, and this is kind of a common misconception when people talk about HIPAA, right? To be subject to HIPAA, you've got to be what's defined as a covered entity under HIPAA, which is typically medical providers, and that can also extend to employer-sponsored health benefit, health insurance plans. Now, employers themselves are not really technically a covered entity under HIPAA, but there are also ADA medical confidentiality concerns you have to take into account. So even putting aside HIPAA, The ADA, of course, requires employers to, maintain medical records in a separate file, maintain the confidentiality of those records. So you're still going to want to, even putting aside HIPAA, you're still going to want to maintain any of these records confidentially. If you know of an employee who has tested positive for COVID-19, the CDC, or is showing symptoms of COVID-19, the CDC's put guidance out there on what to do with that employee, and also what to do in terms of notifying other employees who may have worked in close proximity with that employee. But the one thing that they make clear is that, hey, we do not want you, you can tell employees who've worked in close proximity with an employee that's showing symptoms who's tested positive, you can tell them that, hey, you worked in close proximity with somebody, we're going to send you home for this 14-day period until you're ready to come back in accordance with the CDC guidelines. But you can't tell them, oh, this is the name of the employee who actually tested positive or is showing symptoms. So you do need to keep in mind those confidentiality concerns whenever you're dealing with these medical issues for employees.
Thank you for clarifying that. I'm also under the impression that with your screening checks, if you're logging that information, it has to be kept in a separate file, correct?
Yeah, that's what they're recommending. Really, like any sort of medical record, you want to keep it in a sort of a separate confidential file, separate from their general personnel file that you might have with things like performance reviews and other things like that.
Now, Ross, do you recommend that employers be logging their temperatures, or would you suggest not even keeping a log or a record of that?
I don't think it's necessary to keep a log of every temperature you take, but if you do keep a log of it, keep in mind those confidentiality concerns. I think it's a good idea if you do have employees who you take a temperature of and you're going to send them home or take some action that you wouldn't normally be taking towards them because of that. Probably maybe a good idea to keep a log of it then and maintain that confidentiality, separate file and all that. But if you're testing for every single person, somebody logs a temperature that's just normal, I don't see any reason why you need to be logging your records in that situation.
Okay, good to know. All right, so moving on to physical distancing, that's the new term. A lot of people are using social distancing, but physical distancing is what we should be doing. So make sure to enforce that with your employees. It's really easy to get back into old habits, and people in the South, we like getting close to each other. So just making sure we're communicating expectations when people are engaging with others. And you have to think about your specific work areas. So are you putting people in a place that doesn't allow them to be physically distant from each other, and how do you solve that, or how do you fix that? So that's something you really need to think through for your environment. On the same thing, if you have to have people that close together, the CDC and the Louisiana Department of Health and Governor Edwards all strongly urge these face masks, right? And so wearing cloth masks and protective face coverings is part of the new normal. Your mask protects me and other people, and my mask protects you. So state guidance is that employees of a business who have contact with the public must wear a mask. Anyone have anything additional to say on that? Either of those two topics? Okay.
I was just telling the face coverings, that was something that was covered in the governor's order that came out last week, that, going forward, they are going to require that if you have employees who, quote unquote, have contact with the public, you're going to want to make sure that those employees are wearing their masks.
Well, and now they have a way to report businesses that don't. So it's really important that you think about your business and those face coverings.
I will add that it's important that that people need to be wearing them correctly.
Yes.
I saw somebody yesterday had it on, but it was around their neck. I'm not sure what the purpose.
Oh, like mine.
Well, Chris, you're in an office, but this was out in the public. It was a public service type thing, and so I think it's wearing the mask and wearing it properly is key.
Well, and with that being said, PPE training is probably really important with that. So if you're handling the front of your mask, that's where the infection probably will be. And so I kind of try to pick mine up and off from the sides, so that I don't touch the front of it. But PPE training is pretty important if you're going to provide those tools for your workers. So looking at common spaces, make sure to address these areas in your infection control plan. And of course, depending on the size of your space will depend on how many people should be in the room. So if you have a common space like a kitchen or a break room, does that normally get 6 or 7 people in there, or should it only have 2 or 3 people in there? And who's sanitizing? Do you have those things posted? Are they cleaning up behind themselves? You know, it's the new normal, right? So this is, extra caution when people are at work is to make sure that we've set rules for the common areas and the common spaces. Employee meetings. Also, I mean, if you're having this regular weekly employee meeting or daily employee meeting, that might be some sort of pre-shift or leadership gathering. Look at other methods to do that. There are free ways to get on things like this. So there are Skype and Google Meets and Microsoft Teams. And so all of those things have a little to no cost if you're a smaller business. And, even though we're in the same building, we still have our employee meetings by conference call or through one of these methods so that we can be socially distant and maintain a safe space. All right, moving on. So we have a few scenarios built out through the presentation. Scenario 1 is the employee, I'm gonna let actually Jenny take it. Go ahead.
Okay, scenario 1, employee returns to work with symptoms against company policy or is dishonest about having COVID.
So Janelle, what's your thought on that?
Well, so there's a couple of ways to look at that question. I think that if they return to work, hopefully if you've implemented a screening process, then that's should prevent any any sick employee or anybody come in that could potentially infect the rest of your employees or your customers. So hopefully you've implemented those screening steps. But if, for example, this also goes into about being dishonest. Let's say they answer dishonestly to those questions, and are asymptomatic in that they don't have any other symptoms, including the fever. Then I think that goes to your policy, is how you have to anticipate what if. What if an employee comes in and was dishonest? How are you going to handle that? What if an employee inadvertently didn't know that they were sick, and how are you going to handle that? So I think that all goes to your policy development. In some cases, I have seen cases where there have been dishonest employees, and we've decided that that's like any other falsification, and it's resulted in termination. I have seen cases in other companies where they have also included coming to sick, and not even COVID necessarily, but in this day and age with COVID, have added being really sick and coming to work as part of the life critical rules, which puts you on a different spectrum of the disciplinary process. So I think that's really critical to look at your policies and establish that before you open back up, and know what those scenarios that you might come up with and how you're going to handle those. And then when you have them, be consistent.
Thank you.
Any other comments on that?
Yeah, I'll chime in. I agree with, I think Janelle made some really good points there. I mean, you look at this scenario on its face, and you've got, potential issues of dishonesty or giving false information, right, to the company, maybe possibly insubordination sort of issues right here. If they're returning to work against orders, they're told, hey, here's the CDC guidelines on if you previously displayed symptoms, there's a certain amount of time you've got to stay home and be symptom free before you're good to come and return to work. And if you return to work prior to those deadlines hitting, or if you're still showing symptoms, obviously we don't want you coming back. And if you do come back, we're still going to tell you, hey, if you're showing symptoms, we want you to go home, comply with those guidelines. If you get pushback from an employee who is showing symptoms and they don't want to go home, we want to try to talk with them. And it's a sensitive time, unprecedented time in the workplace. You don't want to go nuclear at first, right? And say, well, if you don't leave, we're going to fire you right here on the spot. What you want to do is you want to try to explain to them, okay, well, we're asking you to leave, but if you do have some sort of sick leave, paid sick leave, explain the benefits that you have available to them when they are being sent home. And a lot of times there's different things that are in play for different companies. Depends on what your policies are, your paid time off policy, sick leave policy, whatever you might have in place. And then of course, depending on the size of the employer, if it's an employee with symptoms and they ultimately go to seek medical treatment or a medical diagnosis, that could implicate those paid leave requirements under the FFCRA, right? So there's a whole host of issues that could come into play here. But the general sort of thing is to be cognizant of is if an employee is showing symptoms in the workplace, you absolutely have the right to request that they leave the workplace and comply with those CDC guidelines. And ultimately, if they refuse to comply after you've explained to them what sort of benefits and how the company can work with them as far as accommodations and all that goes, and they're still absolutely refusing, if push comes to shove, this is something that you could discipline them for insubordination. And then of course, the second part of this, if they're giving false information, if they're representing to the company that they're showing that they have symptoms of COVID-19 and it's ultimately found out later that they were not showing any symptoms, anything like that, of course, discipline could be warranted there and likely would be. Just remember with, dishonesty and falsification issues, sometimes got to make sure documentation and everything is pretty solid because those can be difficult things to ultimately prove.
Absolutely. All right, we're going to look at the next scenario.
Okay. Employee calls into work and has a pattern of absences. They call into work because they don't feel well and think they should not be in the work environment during a pandemic. Thoughts?
All right, so thoughts about that?
Yeah, so they don't feel well. So that, again, could be interpreted a couple different ways. So if the employee considers themselves maybe to be in a high risk category, right, because they are already ill, and perhaps that's the scenario here. So on that one, then I would say that you need to come up with if you haven't already, come up with some guidelines on what do we do with employees that are high risk. And that could be anybody who has been a cancer survivor, has any number of things, diabetes, that's, if you look at the CDC guidelines again for guidance on that, and then how would you handle that for your environment, for your business, based on, realize that's a little bit more difficult for smaller businesses because you need everybody, all of your employees at work. So you have to figure out how you would handle those employees that are in high risk. Again, like Ross said earlier, look at what your leave policies are, if that's the case, if they could use vacation time, if they could use, they're not really sick at that point, if it's just that I feel like I'm in a high risk category. But in this other case where it says, okay, I don't feel well, and are they looking at, I don't feel well, so I don't shouldn't be in the environment, perhaps for the well-being of their coworkers or their customers, then that's another avenue, another way that you have to look at, again, what are you going to do with an employee that, are they exhibiting symptoms, or, those screening questions that you want to come up with. Well, when you say you don't feel well, you're going to have to get into that. Do you have these symptoms, the fever, all this that are listed. And then you have to go through what that protocol is to determine if they should not be in the workplace, or if it's okay for them to come into the workplace, but then continue to monitor their symptoms and maybe put them in a role where they're not in interaction with customers or or with the public or with their coworkers.
So if they're not experiencing symptoms of COVID, but they just generally have maybe a tummy ache, and they're in a pattern of absences where maybe this is their final, let's say, their final warning, would you recommend moving forward, or how would you look at that?
Yeah, so in that case, then I would take the pandemic aspect out of it, because then you look to whatever your normal policies are. So if it's just a normal, there's no fever, there's no COVID symptoms, it's just I don't feel well, then you just I would suggest that you look to your current policies for attendance and apply those policies. If it is, you're saying a tummy ache or something like that, but that's just a little bit easier. If they're running a fever, if they're having respiratory issues, then, and I'll look at Ross, because I'm thinking that may, then you have to kind of walk that fine line of, could it be COVID, and should we may give a little more consideration in that case. So Ross, I'll punt that over to you.
Yeah, and those are good points. I mean, and I've dealt with, over the past several weeks, with this sort of scenario, I've dealt with countless variations of this with various different clients dealing with different employee leave issues. So the first part of this, they call in and they say they don't feel well. Well, what exactly does that mean? Just like Janelle was getting at, are we dealing with a situation of potential COVID-19 symptoms, fever, shortness of breath, the dry cough, all those sorts of things? Or is this some totally unrelated medical issue that really doesn't have to do with COVID-19? If it's something that's totally unrelated, then generally in most situations, you're right, you can take the pandemic sort of FFCRA, all that aspect out of it, and you're considering more sort of normal FMLA, ADA potential issues, right? Now, the one kind of caveat I'll put on that is, and I've seen this situation come up as well, where it's an employee who might not feel well, or let's change it up just a little bit and say that they've got a note from their doctor that says that they've got some other condition, say like diabetes or something like that, and that condition puts them at a higher risk for complications if they were to contract COVID-19, and this doctor is recommending that they stay home or not go into work for a certain period of time. That's a situation that could implicate that second prong under the paid sick leave requirements of the FFCRA, right? You got somebody who has been advised by a healthcare provider to self-quarantine related to COVID-19 concerns. So it just goes to show that the importance, and like Janelle was saying, of having guidelines and these follow-up questions in these sorts of situations, right? I mean, you have the right as the employer, if an employee just says, hey, I don't feel well, I don't think I should come in while this whole COVID-19 thing is going on. You definitely have the right to follow up, ask questions. What are the symptoms? What's the issue? Do you have a condition? What symptoms are you showing? How does that affect the employee's ability to actually perform their given job, right? So these are all things to be cognizant of. We've also seen the situation where you have an employee who doesn't necessarily even have a health condition or anything like that, and they just say, well, I'm just kind of scared to come back to work while this whole thing is going on. And if you do have that situation where it's just that on its own, you got an employee, there's no other sorts of health issues in play, and they're just scared to return. In general, you should be able to require them to return to the workplace. There is a standard under OSHA where employees can refuse to return to work if they believe that they're in imminent danger of a serious physical harm or death, and that the danger is so imminent that OSHA couldn't come in and take some precautions or do something. And in the vast majority of workplaces in the United States, that standard is not going to be met. And it could possibly be met like in a healthcare setting if employees didn't have the PPE they needed, stuff like that. But just in most businesses, that's not going to be met. So if you simply have employees who are refusing to show up because of just a fear of being infected, again, you want to try to talk with them and be cordial and not just slam the door and say, hey, if you don't show up on Monday, we're going to terminate you. But you know, you need to be cognizant of the fact that we can and ultimately need these people at some point to ultimately return to work.
Ross, I'd like to follow up on something. So, and you mentioned if an employee's in a high risk category and they get a, from a doctor saying that they should be at work. I know for larger businesses that we have occupational medical facilities that we contract with constantly, but for small businesses in particular, which I think most of our audience is probably small businesses, I don't want them to think that, our hands are tied. The employee got a note from their doctor. What are their options? Do they also have that option, even though they don't normally do that? Could they reach out to a local occupational facility and get a second opinion that, for example, because we do that here, where they'll get reevaluated based on their doctor's recommendations. And then they say, well, if the person can wear a mask or can physical distance in their job, then they can come to work. And so typically we'll allow that. But for small businesses that don't normally have that access, what's your recommendation?
Yeah, and unfortunately with the FFCRA, let's say if it's a small business, less than 500 employees, such that they're subject to the FFCRA and those new paid leave requirements, there's really nothing in the regs or the law that gives authority to go and require a independent medical examination or anything to that effect. Basically what the guidance says right now is that you as an employer, when you're looking, and this is just under the FFCRA, these paid leave requirements, that you as an employer, you're entitled to the documentation that's necessary for you to ultimately be able to get your tax credit under the PPP for paying these amounts, right? So as an employer, but they don't go beyond that. They don't say specifically what that is. And so, ultimately what the guidance says they're going to be looking for is, hey, what's the name of the employee? What exactly is the condition? What are the symptoms this employee has? If it's a doctor who's ordered them to stay away, you want to get a copy of the note from the doctor, be able to identify who the doctor is and be able to identify that time frame when they're expected that they're going to need to be out of work for that. So again, that's one of those areas where we just don't have the exact guidance yet. We of course know under, kind of standard FMLA, ADA, there's all these rules and regulations that have been in place for years and years about, how often you can request an additional medical certification from somebody, and what sort of records you can obtain and all that. And with the FFCRA, there's just still a lot of kind of blind spots and blanks that we're going to have to kind of rely on the guidance to fill in over time.
I think there's a question in the chat, and it says, if you have leave policies and the employee has a doctor's note citing high risk and they can't telework, but they are not actually sick, should you pay them under SL? I don't know if you heard that.
Yeah, so if it's under, it would depend. If you're talking about sick leave under an employer's own paid sick leave policy, it's going to depend on exactly what the wording of that policy is. If you're talking about, potential FFCRA implications here, that sounds like one where FFCRA probably wouldn't be implicated, but again, it could be one of those where if they've got a note from the doctor that's advising them to self-quarantine because they're at higher risk, you could see a potential argument there that, of course, that paid leave is required, and in that case, they'd be entitled to, of course, under the FFCRA, 2 weeks of paid leave, in addition to anything that your own paid sick leave policy. Remember, with this new FFCRA paid leave, it's 2 weeks, and you can't make it run concurrently with your existing company leave policies. It's got to be something that stands on its own, and then your own sick leave policy can kick in after that if it actually applies.
Yes. Okay, moving on. Let's talk a little bit about communication plan, and that's going to vary depending on your status of worker. Communication plans are really important to differentiate with your employee base. So return to work communication, you're going to communicate the urgent critical items that will prepare your workers when they arrive back to work. So what does it look like when I come back to work? What infection control plan did you put in place? And separate your messaging pertinent to that group of people. So for example, if you're communicating work duties, make sure you leave your groups out that are on leave, so that you don't implicate some sort of compensation due to them. So if you're communicating work to workers, make sure it's only your active working employees that are being communicated with. And I don't know for you guys, but for us, we have a lot of personal email addresses that we communicate to employees with. And so we really take care to make sure that that messaging only goes to the appropriate workers. So active teleworkers, communication for those may be working from home in other capacity or in other capacities due to the COVID concerns. Prep them as far in advance as possible that there's going to be a change in their work environment, when they're expected to come back to work, what day they're expected to be here, and if any of the situations have changed. So if they're physically relocated, that's something that you definitely want to communicate to those people that are affected. And then set the expectations and guidelines from the front end. And if you have teleworkers, some of the questions we had from the IC SHRM group is, how do we continue to hold expectations for that group that works from home? And there's just no way around it but to give them expectations. So make sure you're laying out for them exactly what you expect them to accomplish, and then have them give you feedback regularly, whatever that means for you, in order to make sure that they're maintaining that progress. You're going to need to get that feedback from them. Moving on to the workers on leave. This is the employee population that maybe have COVID concerns, or they're sitting with people or have childcare issues. So they're under the CARES Act, or they're under that paid sick leave part. And make sure you're maintaining communication with this group throughout their leave. So ask for regular updates of their intent to return to work. That's something I do on the front end. So I give them paperwork that says, hey, this is what my expectation is. While you're out on leave, just check in with us as you get updates. That could be weekly or bi-weekly. And then remind them as their return to work date is approaching that they will need a release to return if that is required of them. And then the communication of their responsibilities for their benefit premiums, or to contact their disability insurer, making sure that you're communicating any COBRA that might come into play if their benefits ended. And then if their benefits are going to be restored, when they can expect that. Are there any comments from the panel up to this point on any of those?
No, I would just say that I think what you said earlier about sort of tailoring these communications is definitely a great idea and really necessary, especially, I know we haven't gotten to it yet at the bottom of the slide here, but when you deal with laid off employees, the guidance from the various government agencies right now is that, if you're gonna go and rehire people that you've actually laid off, I'm not talking about just furloughed people who are, temporarily kind of on an unpaid furlough, because technically furloughed employees are still on your payroll. But an actual laid off employee, if you're going to go and rehire them back, you need to go through those kind of your standard hiring process that you would go through with these people. So, it's important, and there's certain expectations that these people need to understand that, hey, when you come in, we're going to need you to go through certain steps. And you want to communicate that on the front end so that when people show up, they're not caught off guard. And likewise with other workers and anybody who's going to be returning to the workplace, if you are going to be doing some sort of screening, whether it's taking the temperature or doing a COVID test, to allow them back into the workplace, I'd recommend that you give them that heads up whenever you communicate to them, so that they anticipate it whenever they arrive at the workplace and aren't caught off guard.
And bringing that up, the part about the furloughed workers and the laid off workers, furloughed is when the employer requested the employee go out on leave. And so that could enact some responsibilities on your end, and laid off workers, and Ross, feel free to fill in, but my understanding is that if you've laid them off and you bring that position back, the employer has a responsibility to contact them if that position opens up again. Is that correct?
Yeah, there's certain requirements under, and this depends on whether there's certain laws that are implicated whenever you actually laid the employees off. So there's certain statutes like the WARN Act, which a lot of you guys have probably heard of the WARN Act before, right? If you're doing a plant closing or a mass layoff of 50 or more employees, you've got to give that 60 days notice to the employees. You've also got to give notice to different local government folks, state government folks. And under the WARN Act, there are certain requirements that if you are going to rehire within a certain time frame after you do that layoff under the WARN Act, you do have to give notice to those laid off employees, and essentially an opportunity for them to come back before you hire other outside persons. So yeah, there are certain things with laid off employees like that you need to be cognizant of it, but it depends on how the layoff was conducted.
Also, I want to bring up the Affordable Care Act guidelines here too, because if their benefits ended and they're in that stability period, so if they've worked for you longer than different people have different stability periods, and so if they're in that stability period, then you may have an obligation to restore their benefits immediately. And so make sure you're looking at your plan summary language for that as well. All right, moving on, there's another scenario.
Chris, how are we doing on time?
We have time, so.
Okay. Awesome, okay. Manager has always suspected that one employee had mental health issues. They are very concerned about that person during this time, and the manager decides to ask health questions outside of COVID symptoms to ensure they are mentally stable. I've seen a lot of those. Head shaking.
All right, so I'm going to go with Janelle first. What is your thoughts on that?
Yeah, no, don't. Here's the thing: if take COVID out of it, if you suspected the person had some issues in the past, then those should be addressed, and without you asking. Nobody needs to be playing doctor except for the doctors. And so, taking COVID out of it, you've got an employee that maybe you are legitimately even concerned that with the additional stress of the circumstances, the environments that we're in today, and that may be a true, genuine concern. Do not ask questions. You can refer them, hopefully, if you have an employee assistance program, or to try to assist them in getting some help otherwise. But certainly that is not for anybody, any manager, supervisor, or coworker to be playing medical professional. Ross, I'll let you jump in.
Yeah, you're absolutely right. I mean, we talked about earlier about how the recent guidance has kind of relaxed some of these regulations and limitations on an employer's ability to conduct medical examinations and ask these sorts of questions. And you can't just use COVID, right, as sort of a blanket reason to go in and start asking all these sorts of questions to employees. And it's one thing if an employee is showing symptoms of COVID, experienced symptoms, or if they tested positive for it, and asking questions, following up along that diagnosis or what the symptoms are. But whenever you start using it to go outside and question other things like this, those special COVID rules really aren't implicated necessarily. And so then you go back to the more general guidance, which is very restrictive in terms of the sort of quote unquote medical examinations and questions that employers can ask of their employees.
Awesome. All right, moving on. Looking at potential discrimination, the question up here is, how much information may my employer request from an employee about their health? So I'll tell you from my aspect, I just kind of stick to what the FMLA guidelines are. So whatever is on the FMLA form, when it has to do with a leave reason only, just not for any reason whatsoever, right? Mm-hmm. So when it has to do with a leave reason, I kind of stick to what FMLA guidelines are and what you can collect, what information you can collect through them. And when an employee requests a reasonable accommodation, there's that enacts another way to collect information in order to determine if it's a reasonable accommodation. So during a pandemic, ADA covered employers may ask employees if they're experiencing symptoms, as we've talked about throughout this presentation, and employers have an obligation to keep that confidential. So we don't want to just ask health questions to ask health questions. So that could enact some sort of other reason why we're asking. Anyone else have something to say on that?
Yeah, I would just say, I mean, there's great guidance on the EEOC's website regarding not only this topic here, and when we talk about discrimination in this context, we're talking more about FMLA interference discrimination or ADA discrimination. So the EEOC's put out some real good guidance on that to kind of guide employers. And they've also put out some guidance as far as other forms of discrimination that you could see in the workplace tied to COVID-19, such as discrimination based on one's national origin or race. And what they're getting at in those situations is basically, employees making harassing comments or discriminatory comments towards Chinese national employees, or maybe employees of another Asian country, something like that. But in general, you're entitled to use, kind of your general FMLA forms. If it's an ADA situation, of course, when we talk about reasonable accommodations, we've got the interactive process under the ADA, right, that we've got to go through to see, exactly how, what is the condition this person has, how does it affect their ability to perform their job, what accommodations do they think would allow them to perform the essential functions of their job, are those reasonable accommodations, does it impose some sort of undue hardship on us? So we're entitled to request information and documentation to allow us as an employer, allow you as an employer to answer those questions and determine those things. But again, I would point you in the direction of the EEOC guidance that's been put out on this. They've done some really good Q&As and other guidelines for employers to kind of try to help guide everybody in dealing with these sorts of situations.
And there's a new one out right now. So looking at I'm going to skip over this scenario because I feel like we've addressed scared employees reporting back to work. Let's look at the guidance. Let's skip right to the guidance. So if employees are concerned about returning to work, there's lots of guidance out there. One is from SHRM, the Society of Human Resources Management. And it's in an article called What to Do When Scared Workers Don't Report to Work Due to COVID-19. And some of the items that are covered in that article talk about looking for their specific concerns, actively listening and asking clarifying questions, treading cautiously with health information. So we talked about that today. Employees do have legal protections. OSHA has some guidance for employers as well, and ADA may require employers to make changes to an employee's work environment, like installing plexiglass separators or other barriers between workstations. And then of course the FFCRA, which has some regulations which permit employers to require documentation for paid sick leave. So those are some of the guidances out there. I don't know if any of you guys want to expand on that at all.
Yeah, well, I think, really at the end of the day, and I think we touched on this a little bit kind of throughout, is that the employers need to do what they can following the guidance that's out there from CDC on what they can do in their workplace to make it a safe workplace. right? As safe as reasonably possible. So, and so then you have to communicate, that goes to that communication plan with those employees when you're going to bring them back into work, assuring them that, hey, here are the things we put into place. Here's how everything's going to work. When customers come in, when other employees come in, the sanitizing, the additional hand sanitizers and soaps and things like that, and temperature screening if you're going to be doing that. So I think that it's all in, just like we would have in normal circumstances, making sure your employees feel safe coming to work, and communicating that, and making sure they have access to the resources in case they have questions. If they want to double check what you're doing, that's fine. Provide them with links to some of those sites, so that they can, make sure that we're all doing what we can to be safe.
Absolutely. All right, so looking at the fifth scenario, we have a few more minutes here. So I think Ross addressed this, which is, an employee is joking around with a Chinese national employee about starting the COVID pandemic. So I think we've all discussed that that's not okay, right? So we need to make sure that we set those expectations with our employees, and then take a look at the EEOC guidance that was updated on 4/23 about harassment due to national origin, race, or other reasons why we all should be able to come to work and not feel like our race is hindering our ability to complete our job, right? So looking at scenario 6, an employee at an essential business is unreliable and doesn't perform to their best ability. The employee was the first to take leave under the paid sick leave, and you need them to be at work. The employee comes back and the supervisor gives them the worst shifts and decides to find ways to make life difficult for the employee. Is that okay?
I'll give a legal, can I give you HR/legal? It depends. So from an HR perspective, and then we'll let the expert jump in with the legal aspects. I would say, again, you need to treat people as you would normally treat them, regardless of the COVID, regardless of the fact that they were the first person that went out on leave and they've stayed out the longest, or whatever the circumstances are. Again, if you had a performance issue with an employee, that should have been addressed long before COVID. And so bringing them back, can you put them on the worst shift? You could, but you need to make sure that it's not, trying to pick my words wrong. So you need to make sure that it's not in any way going to be discriminatory, or could be misconstrued as being discriminatory, or anything like that. If you're trying to get them to quit, that has its own legal implications as well. So, I think, again, there's what you could do and what you should do. And I think, I think you should return the person in a generic scenario. You return them to the job that they had, the shift that they had, and everything else, and see, how they perform, and then address that. But you have the right to run your business the way you need to run your business. And if you need that person on a particular shift and it happens to be the worst shift, then so be it. Just be prepared for any kind of discriminatory action. So Ross, I'll kick it to you.
Yeah. And I think what you're getting at there is you got to have, right, if you're gonna do this in this situation and put this person on the worst shift, or somehow change their work conditions to be in some way less desirable, whether it's some other sort of change, right, you need to have a legitimate non-discriminatory reason for doing so that if the employee was to file some sort of claim or lawsuit, right, that's ultimately what the employer in that situation has to do to defeat that lawsuit. You're gonna have to prove and show that you had a legitimate non-discriminatory reason for taking this move against this employee to change their terms and conditions upon returning to work. This scenario right here on its face is really kind of a classic retaliation sort of situation. And so just like under the ADA and the FMLA, the traditional FMLA, right, they both have anti-retaliation provisions in there, where if somebody takes a leave under the ADA and then comes back from leave, and likewise if somebody takes leave under the FMLA and then returns, right, it's unlawful to retaliate against that employee because they took a leave or because they're disabled under the ADA. And so ultimately, if if you do take some sort of action against an employee when they return to work, and sometimes you see this where it is tied to a legit performance reason. You might have a situation where you had an employee who had a host of performance issues, and you're getting ready to discipline them or meet with them and counsel them, and then all of a sudden they go out on leave for some reason that's totally unrelated to the performance issues, and then they return to work 2 months later, and you say, well, we were going to discipline them for this thing that occurred prior, but they just got back from leave, so if we discipline them now, is that going to look like retaliation? And what the law says on that is that you as an employer, you absolutely have the right to take an action against that employee if you would have taken that same action if they had not taken leave, or if they, if they did not have a disability. So you're still okay in carrying through those disciplinary reasons, but again, you got to be able to show a legitimate non-discriminatory reason for doing so. And in general, in this scenario here, just because you're an employee took leave, you certainly don't want to take any action like this against them just because they were the first person to take FFCRA leave or anything like that.
So there's a question coming from the chat box. Is there any guidance for employees who are being forced to return to the office, even though their position allows them to easily and effectively work from home?
Well, ultimately, the decision to allow or not allow employees to work from home in general, to allow employees to telework, that's ultimately the employer's decision generally, if they want to allow that or not. Now, if it's a question of an employee who has some sort of disability under the ADA or something like that, and they're requesting to work from home as an accommodation under the ADA during this time, well, then you've got to go through that interactive process under the ADA and determine whether or not they have it, whether or not they're disabled, whether or not this actually affects their job functions, see what accommodation they're requesting, whether it's reasonable, and can we accommodate it. So it's one of those situations where you got to look at what the reason for the employee wanting to stay and work from home is. Can they tie it back to some sort of medical issue, COVID-19 related or not, or is it just, hey, I don't want to come into the office while this COVID-19 thing is going on. I'm just kind of scared to return, just like we talked about earlier. In those situations, whether or not you're going to allow employees to telework, work from home, that's up to the employer's discretion.
Okay, I'm going to move on to, if everyone's good, move on to the last slide, just because I think this is important before we stop. And I think we kind of talked through policy changes, but if you have further questions at the end of the presentation, we'll be happy to stay on and answer those for you. Looking at this last part, which is employees exposed to COVID-19, the CDC recommends for healthcare providers 3 separate strategies to bring people back to work. And there is a poster out there on the CDC website for employers and employees that you can utilize this as you're coming back to work, setting the normal. And so with your symptom-based strategy, it is a 3-day, 72 hours have passed. So you see symptoms, you might have gone through your pre-testing, you see symptoms, and so you're saying, okay, at least 3 days, you need to resolve your fever without the use of fever-reducing medications, and improvement in respiratory symptoms, and 10 days have passed since the symptoms first appeared. So that's your symptom-based strategy. Symptoms occurred, you send them home, they have 72 hours where they're not experiencing symptoms anymore. Then if 10 days have passed and 72 hours have passed where they haven't experienced any symptoms, then maybe you use that as a strategy to come back to work. That's the symptom-based strategy. And then if you go through the time-based strategy, you might exclude them from work because maybe they have no symptoms. So then you use the CDC is now saying 10 days have passed since the date of their first, maybe they received a positive COVID-19 test. And so they've never had symptoms, but now 10 days have passed. For healthcare workers, they're saying you can come back to work. That's their new guidance right now. And then if they have symptoms and the test-based strategy, with the test-based strategy, so they've tested positive for COVID-19. They've resolved their fever without the use of fever-reducing medications. There's improvement in their respiratory symptoms like cough and shortness of breath, and they've had 2 negative COVID-19 tests within 24 hours apart. So that is the test-based strategy with symptoms. Test-based strategy without symptoms would be two negative results of COVID-19 tests collected with 24 hours apart. Any additional comments on that from the panel?
I would just comment again, the CDC's website actually has a COVID-19 page, which contains this guidance as well as a lot of other good guidance they put out there. Also in terms of, keeping the workplace safe and clean and what you need to do as far as disinfecting the workplace, things like that, which I know we kind of touched on briefly earlier. And with all these different guidelines for the timing of returning to work, it's all tied to, the various, and it's evolved actually. It was 7 days and then they've upped it back to 10 days. It's all evolved based on the understanding of how the virus works and the incubation periods and all those sorts of things. They also have guidance on there for what you should do as far as employees who may have worked in close proximity with an employee who tests positive or is showing symptoms, and there's guidance on that as well. The last I believe that I saw, and it may have been even revised further in the last week or so, was to if you have an employee, if you do have a situation with an employee who's tested positive, and the first thing you're supposed to do is to ask that employee, who have you worked in close proximity with over the last 48 hours before testing positive or before showing symptoms of COVID-19. And what they're getting at in close proximity, they're talking about employees who worked within 6 feet of that employee for 10 minutes or more in the 48 hours prior to showing symptoms or testing positive. And what they say for those employees is that you should send those employees home and tell them to remain at home for 14 days from the time they were last around that other person who had COVID-19. And so again, there's various guidance on the CDC's website as to how you can handle these sorts of scenarios that may come up if you have an employee who tests positive or is showing symptoms of COVID-19.
So one last thing before we get off, and that is the governor gave guidance on Monday that if you need help for your business and tools and resources to help open your business safely, you can register your business on opensafely.la.gov. And they will be in contact with you and help you to follow all the changes and regulations that are coming through as far as government guidance. At this time, we're going to open it up for questions if anyone has questions. Okay. All right. I don't know if the chamber's still on, but do you want to? Okay. So, oh wait, we have some questions. Here we go. And I think everyone's comments are thanks for your guidance and support. Ross is with Stockwell Siebert, so if you need legal guidance, please feel free to reach out to him. If you're interested in following IC SHRM and what we have to offer, or just need guidance in general about your business, I encourage you to join. Membership is free. And so you can go to icshirm.shirm.org. And you can get this presentation on our website, as well as there's some other tools on there about helping return your employees back to work. Thank you all for being here, and we'll see you next time.
Thank you all very much. It was very good.